All right, in accordance with the Open Public Meetings Act, PL 1975, Chapter 231, adequate notice of this regular meeting of the Planning Board of the Township of Franklin has been provided. If everyone could please stand for the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, so the minute, oh yeah, take the roll, sorry.
Councilman Chase,
Here.
Carl Hauk,
Here.
Alex asked to be excused. Cecile McIver,
Here.
Robert Metler,
Here.
Safa Masre,
Here.
Charles Brown,
Here.
Robert Thomas. Jennifer's on vacation. She has to be excused. Godwin's not here. And Chairman Orsini.
Here. Okay, so the minutes from the last meeting aren't ready yet, so we'll move right into the resolutions, which the one we have, you will have gotten in your email. It's for Somerset Atrium, PLN 17-00007.
Move to approve.
A second.
Second you. Okay, so there's two parts of it. It's a subdivision and site plan. So I'll do one at a time, or do you want to do them together?
Voted separately, but they were voted, the resolution memorializing both those, so you can just.
Okay.
So you do them both together? Okay. Carl Hauk,
Yes.
Cecile McIver,
Yes.
Robert Metler,
Yes.
Mustafa Manzre,
Yes.
Charles Brown,
Yes.
and Chairman Orsini.
Yes. So one hearing tonight, Aisha Abraham, PLN 17-4001, has been carried to September 6th, 2017 without further notification. So if you're here for that, we'll be hearing that on September 6th. The public comments. Make a motion to open to the public for any item that's not on tonight's agenda.
Mr. Chairman, I would move that the meeting be open to the public for anything anyone would like to say, except on applications that have their own public meeting.
Second the motion.
All in favor?
Aye.
Meeting's open for any general public comment on planning.
Seeing no one coming forward, I would move that this public hearing be closed.
Second the motion.
All in favor?
Aye.
Vouchers, thank you, thank you. All right, I skipped over vouchers. Don't want to get Peter
I
mad.
thought it was something I said.
Entertain a motion to approve the voucher for our planning board attorney for the July retainer in the amount of $833.33.
Move to approve.
Second.
Councilman Chase,
Yes.
Carl Hauk,
Yes.
Cecile McIver,
Yes.
Robert Metler,
Yes.
Mustafa Manzre,
Yes.
Charles Brown,
Yes.
and Chairman Orsini.
Yes.
Thank you.
No problem. So tonight, I'll obviously be doing the agenda in any order in which I feel. So anyway, to go back to what the actual agenda is, our first hearing is 7276 Madison Avenue, LLC. Groundhog Day.
Picking up, yeah. Members of the board, Peter Lanfrit appearing on behalf of the applicant. This is an application for a major subdivision approval on property known as Block 540 and also Block 543, lots 1.01, 4.01, and 1.01, 557 and 567 Madison Avenue. This application, this property was the subject of a previous application for a minor subdivision that was granted a few years ago. The property was then since sold to the applicant. The applicant currently owns the property, and this is an application for a major subdivision. I have with me Mr. Ford, who will be presenting the testimony this evening. The applicant is here. I don't know if it's necessary to call him, so I will just go with Mr. Ford at this time.
Thank you.
If I could swear you in,
Yes.
do you swear the testimony you're going to provide is the truth, the whole truth, and nothing but the truth?
Yes.
If you could state your name, spell your name for the record, and provide your address, please.
Yes. Michael Ford, Ford, with Van Cleef Engineering, 32 Brower Lane, Hillsborough, New Jersey.
Thank you.
Appeared before this board a number of times.
Certified planner, state of New Jersey?
Correct.
Planner and
An
engineer.
engineer.
Okay.
And Mr. Ford, just for the record, your credentials have not been detrimentally affected since last you appeared and were qualified as a planner and engineer.
Correct.
Oh, great, thank you.
Mr. Ford, you prepared the application which is before the board this evening, is that correct?
Yes.
And as I indicated in my opening comments, there was a previous application with respect to the subject property, is that correct?
Correct.
Now, you were not involved in that application either, is that?
No.
Okay. Can you briefly indicate to the board what was previously approved with regard to these, well, first of all, describe the property.
Okay. I'll refer to the exhibit that I have on the Jumbotron. It's the colorized version of the existing condition plan, sheet number 2, that was part of the subdivision application package. What's highlighted in green are the existing parcels. There's one large parcel with a paper street between a smaller parcel, and the subject of the prior application created the 3 existing lots, and that would be one lot to the south, another lot, and then this whole block is one lot. And part of that prior approval was actually an extension of Madison of some about 250 feet pavement to provide for frontage for these 2 lots. Ruth was to remain unchanged. Ruth does have an existing public sanitary sewer in it, though. There is a sewer line there.
Okay. And that would have been a 3-lot subdivision, which would have been a conforming subdivision, is that correct?
Correct.
Okay. Can you now refer to the exhibit that you'll be relying on to show what we are proposing?
All right. Just at the bottom of the page that we have up now, and you'll see the next page also has it, the bottom of the page is Elizabeth Avenue. This is Elizabeth Avenue, and we're just to the north of where Elizabeth Avenue passes under Route 287. So this is close to South Bound Brook, this property. Just off the page where the north arrow is where 287 is existing today. This exhibit is a colorized version of sheet 3, the preliminary plat that was submitted as part of the subdivision application. What's being proposed is to improve that section of Ruth Street that is right now a vacant or unimproved public right-of-way with a 20-foot wide cartway with an intersection at Elizabeth Avenue. There are 6 lots proposed, 3 on each side of Ruth, and they would all access the public sewer in Ruth and have on-site private wells. We're in the R20 zone, I'm sorry, the R10 zone, which allows for 10,000 square foot lots, but 20,000 square foot lot minimum if you don't have public water and sewer. So these all comply in every regard to the public or the bulk standards, with one exception, and that is this one corner lot here, which is a technical corner lot because it fronts on a portion of Madison Avenue that's unimproved, corner lots require 105-foot frontage, whereas that lot would have 100-foot frontage. So there's a de minimis 5-foot deficiency in the lot frontage on that one lot. That's the single variance that is part of this application.
In all other regards, the lots actually, even though they are in the R10 zone, do comply with all of the R20 zone requirements. Is that correct?
Correct.
So
Okay.
you're proposing R20,
Right.
basically.
They're all 20,000 square foot lots minimum.
Now, you said there you only had the one variance, so, but on our, you have there's a through lot.
Oh, excuse me, you're correct,
one
that's
of
right. There also is another technical variance, and that is this large parcel land here backs up to another paper street, Halsey, which is an unimproved road. So technically, they're through streets. They would have frontage on 2 roads. What we would agree is to not ever have access to Halsey. Certainly now, it doesn't make sense because it's not improved. And if the board chose to impose a restriction, we'd have no objection to no access off of Halsey.
And that would be true even if Halsey got developed in the future as a main
Correct.
road.
Right. There really would be no need because we'd have access via the improved section of Ruth.
So is ingress and egress here just through Elizabeth Avenue, or is Madison Avenue actually a usable street?
No, Madison is a usable street.
Okay.
Let me go back to the prior exhibit, which actually widens out and has a larger view of the vicinity, including Hall Street. And Hall comes in to Madison. It extends to the north. There's a Bound Franklin Little League complex there and some other. But one of the advantages, and we came to the staff and reviewed this with them about a year ago when the applicant acquired the property and discussed this concept. And one of the advantages that I think was seen by all with this proposal as opposed to the prior approval where it had just extended Madison another 250 feet is that with that concept, all 3 of these lots plus the other existing residents, and there's only a couple here, would all be serviced essentially by almost 1,300-foot long cul-de-sac. So no other access. By simply improving and completing the connection out to Elizabeth Avenue via Ruth Street, you provide for that circulation and alternate access, in particular for emergency access.
Thanks.
Okay.
Now, Mr. Ford, the application that we submitted was also submitted to Somerset County and the Delaware Arron Canal Commission, was it not?
Correct.
And we received reviews from both of those agencies.
Correct.
And other than some minor modifications with respect to the county is in accord with the plan?
Correct.
Okay. Now, with respect to the plan, how is stormwater management being handled?
Okay. Stormwater management is being handled by a number of, I'll say subtle but important aspects. One being the change in land use. Just like when you add impervious coverage, you create more runoff. We also have an existing large lawn area in this portion of this existing property, which we're going to revegetate and turn into woods again. It adds for stormwater runoff, less stormwater runoff from a wooded area versus a lawn area, but it also couples to provide for a nice buffer between the rears of these lots and 287 just off the page, as opposed again to the other aspect or the other layout that was previously approved where you're extending Madison and you have a house with really no great deal of a buffer between it and 287. The other stormwater management principle that's being implemented, and I see this on even single-family vacant homes now in Franklin, so it's quite common, is each dwelling would be serviced by an individual dry well, if you will. All the roof runoff from the houses would be directed to a dry well and infiltrated into the ground. Then third aspect is, as I described in the introduction, the road is 20 feet wide. That's comparable, if not wider than the existing portions of Madison and Halsey, but it also permits for, without curbs and, other ways of what would channelize stormwater and cause it to flow faster, we provide roadside swales. So the roadside swales collect the runoff from the narrow pavement, utilitarian to be able to service the project, but not overly wide, whereas it would cause more runoff. It also allows for room alongside of the proposed road to provide for those water quality grass swales. And then lastly, the drainage from the roadside swales is directed into periodic catch basins and collected and then filtered through what they generally describe as mechanical treatment devices. These are, again, more common now to provide for water quality measures. And one unique aspect of this project, as opposed to other projects in Franklin Township, it's in the Delaware and Raritan Canal Commission review zone, but also is in a review zone where the requirement for filtering the stormwater, water quality treatment, is at a higher standard, what we refer to as the total suspended solids removal rate. It's typically 80%. We have to be at 95% for this site. So we have a heightened burden to provide for water quality. So there were additional measures taken, and I'll report to the board that in April of this year, we received a review comment memo from the Delaware and Raritan Canal Commission, and they've indicated that all aspects of our stormwater management system comply with their standards, which are also the state standards, again, with that heightened requirement.
Now, in the staff reports that were generated, there were some issues raised with some of the location of some of the treatment structures for the stormwater management. Is that correct?
Yes.
And did we have a meeting this morning with the township engineer concerning that?
Correct.
And did we come up with a resolution on how to deal with those issues?
Yes.
Okay.
Okay.
Can you, again, without boring the board too much, just give a
No.
brief overview of what?
It really, I think, comes down to the maintenance responsibility, in particular of those mechanical treatment devices. Your township engineer made it clear to us that the township isn't interested in having any of those devices located within a public right-of-way where the township would be required to maintain those devices. And I'll Okay. And we had revised the plan when we heard of that concern back in April, and the drainage pattern for the site is such that this easterly portion flows toward Elizabeth Avenue. The western portion flows toward the intersection of Ruth and Madison and into a wetland feature that's on the property. We had an ability, because this was the low point and this is where the mechanical treatment device was to be located, to pull it out of the right-of-way and put it on this private lot. But we hadn't, we had a mechanical treatment device right down at the low point at the intersection of Elizabeth Avenue and Ruth, which was still within the public right-of-way. After our meeting with Mr. Zelnick today, what we came up with a solution, and I'm sure you've heard of this also in other projects, is that we're required to treat our new impervious pavement. But existing portions of pavement you're not required to treat, just like when the town overlays a road, they're not required to add these best management practices. What we came up with a solution is Mr. Zelnick suggested that this mechanical treatment device be pulled out of the right-of-way and put on one of the lots. That would mean moving it upslope and onto the nearest lot, which would then, because of I can't make water flow uphill, require us to not, or leave us with a portion of Ruth that would be untreated. But what we've came up with as a solution is that this existing portion of Madison flows down toward the intersection of Madison and Ruth, and we'll treat that portion of the existing Madison through that mechanical treatment device. Again, a device that's located out of the public right-of-way on a private lot, and it would be owned and maintained by that owner. So I think we've addressed that solution or that concern by moving those mechanical treatment devices, all of them, out of the public right-of-way. So there wouldn't be any township responsibility for maintenance.
When you say maintained by the owner, do you mean like the homeowner of that lot?
Correct. Right.
They're going to know how to maintain one of these treatment things?
Well, all of these projects require a manual, so there'll be a manual. Basically, devices are, I'll say, not that difficult to maintain. I mean, you have to have a professional like that knows how to vacuum it out. It collects debris.
Yeah.
It collects sediment or floating solids. So it needs to be vacuumed out. And then occasionally, some of the devices have cartridges in there that would need to be replaced.
Does the homeowner have to pay for that?
Yes. And your township.
What are the typical costs for a quarterly vacuum and a biannual replacement of cartridges?
The developer actually went to the supplier to check on that, and they came up with a cost, I think, of $2,500 to replace all the cartridges, but that's not something that needs to be annual or biannually. And, you know, they have a number of cartridges in there. Usually you don't have to replace all the cartridges. And here I can give you an example of a device that's been in place for a while, and we're part of the township inspection program where we are, the owner is required to report to the town about their inspections, and that would be the new building at the intersection of Franklin Boulevard and Hamilton, the Dr. Swords' building. That has a mechanical treatment device in the parking lot. And that's been there for a number of years now, and at least 3 times, I think, we've already inspected it and issued a report to the town. And there's been no accumulation of sediment in that, which, you know, albeit addresses that entire parking lot, that would warrant even vacuuming yet. So I think it really depends on the use. It's similar to like a septic system in a way where, you know, you pump out your tank every 3 years, but some people don't have to pump out their tank every 3 years even. Doesn't accumulate that many solids. And then there's other people that might have to, because of the use of their house, pump it out more frequently, even on an annual basis. So.
But would you say that usually manufactured treatment devices are responsibilities of homeowners associations or commercial type landlord developments other than a single-family residential house?
Yeah, I would say that'd be more typical, yes, yeah.
It's a cost.
Right. And
Yeah, I find it next to impossible to believe that somebody, individual homeowner, I mean, it can be compelled to pay for this. And not only that, are they going to be, is that going to be disclosed before they buy the house?
That's a good question. There is a deed recording required, both the maintenance manual. First, the Delaware and Rare Canal Commission requires a conservation and maintenance agreement to be registered. And then there's a requirement that a deed restriction be recorded for the property that includes the maintenance manual attached to it. This is just like these devices are becoming more common, and we're working our way into the state's new stormwater regs. So are these recorded devices and means of.
And two of these properties are not going to have one but 2 systems on it, right? They're 2 storm septic.
There are two
So they're going to have to maintain
devices.
2.
Correct.
In order to get your 95% TSS. And that's on top of the porous pavement driveway, which you're proposing, which will have to be vac out.
And the dry well.
On all these properties.
And the dry well, correct.
And the dry well, yeah.
Right.
And who would inspect them?
They're required to have a professional, this is actually part of your township's ordinance, that they have a professional inspect them and report to the township. And they pay a registration fee with the township.
But here's the thing. I mean, these requirements, I mean, you had mentioned the Buster Services project. I mean, that is a commercial property. If you think about dry wells, or I think you had mentioned septic, all those examples, they're collecting runoff or effluent from their own development. It's their responsibility to manage their own stormwater runoff, or if it's a septic, the treatment. This is accepting runoff from a public road, and we're putting this responsibility onto a private homeowner.
And-
I
I
don't
think the
understand
operative
this.
word is "we."
No, it is the applicant who is putting the responsibility on the private
You're
homeowner.
asking this board to approve this subdivision. So the planning board and the township's
Right.
putting this responsibility on them too.
So, other thing at which I'd like to, say we're talking about the corner lot on, whatever block, it's 543 lot 1.04, that's the corner lot of Madison and Ruth. So that lot there not only has to do, maintenance on a dry well, but also the porous pavement driveway, I'm assuming the swale in front of the house, as well as the 2 manufactured treatment devices.
Well, the swale in front of the house is actually in the public right-of-way, and that would be
Well,
just
that's
like
part
any
of a
grass.
stormwater feature as part of getting your TSS removal, so that is part of a stormwater system that the township, as noted in the engineer's report, should not have to maintain.
They asked for the mechanical treatment devices to be placed out of the right-of-way. And let me go right to, I think, part of the thrust of the township's report about, there was a suggestion actually for stormwater management to not build one of the houses and put an above-ground basin here. First, because of the topography, even if we did that, we'd still have to treat the water quality for that portion of Ruth that runs out to Elizabeth Avenue. And then with any detention basin, even the best, like the higher level ones, like a bioretention basin or a sand bottom basin, you don't get to the 90% TSS removal, so you'd still need a mechanical treatment device to get to that higher level of treatment. You know, that when you're required to have these higher levels of treatment, you put the stormwater quality features in series, so it treats it to one level through one best management practice device and then to a higher level through the next one. So, I mean, we'd looked at that, and there really wasn't, I'll say, a great benefit, and you'd still end up with now you'd end up with an above-ground basin that someone would have to own and maintain as well.
For the record, the township does not maintain the swales, such as like the Bot Lane, does not maintain the swales in front of the property.
Well, that can be
Private
just like,
property.
Yeah.
And
Okay.
this being a stormwater feature, such as a drainage swale, as required by the township ordinance, would have to be registered, and there would be an annual permit for that property owner to have that inspected per linear foot. And whatever cost that is for the permit would be for that homeowner on the corner lot. 4 or 5, 1, 2, 4 features.
Well, let me put it this way. I'm not comfortable with this arrangement. I mean, I don't think it's a burden that I personally would want to place on somebody. I mean, I suppose we could take a free market view of things and say, well, you know, if somebody's willing to do it and buy the house, then, but what happens when that person who might be willing then tries to sell the house to somebody who's, you know.
Mr. Chairman?
Yeah.
Yeah, I also have a problem in the sense that with all, forgive me, but I could see a lawyer coming along to the homeowner and saying, well, you shouldn't have to pay for this because it is servicing the streets more than it's servicing your own lot. And so it could become an interesting law case. Over the years, there have been several cases where it's been X versus the Township of Franklin that has become, like Terhune versus the Township of Franklin wrote some of the law about the farmland tax. So I don't know that we want to be writing the law about these newer kinds of devices.
If I may, with all due respect, we are required to provide stormwater management as part of your ordinance, as part of the DEP regulations. The system that we have provided has been reviewed by the DRCC and DEP, and it does in fact work. How it is paid for and maintained in the future, That's a decision that the owner of the property now is going to make, and he has a couple of options. One is, again, he can, by deed notice, which is going to be required for these 2 lots, and all the other lots have language in the deeds, so I don't think that's the issue that Mr. Metler raises is as relevant, because any prospective buyer will have that notice that they are responsible to do A, B, C, or D, as the case may be, depending on the lot. Obviously, my client may have to sell those lots that have some of the greater restrictions that are priced less than some of the other lots that are unencumbered. But that's my client's choice. I think as long as we provide for the stormwater management and all of the appropriate deed notice filings are filed to put everybody on notice, I think we have done our job. In addition, this township is very, very stringent, as Mr. Howe has indicated. They have numerous regulations with regard to all of these devices that are on private properties where they have to be registered and inspected on a regular basis. So there is no detriment to the township as to the maintenance of these systems, because the township has to know that they're being properly maintained.
Couldn't it be done through a homeowners association?
That's also a possibility.
I mean, where at least everybody has some skin in the game there, at least?
That's also a possibility, and sometimes, Mr. Orsini, it's more difficult to sell a project with a homeowners association where people may say, I don't want to get involved in an association, especially when it's only 6 or 7 lots. So I don't know if, you know.
Let the poor schmuck at the end of the block take care of it.
Well, except he's probably getting a benefit when he buys the house, and he's aware of it. I mean, I don't think that decision is a board decision. I think that my client can make that decision, and he may very well decide to create a homeowners association if he feels it's most appropriate.
Can you clarify the client one last time what led to you moving that feature on the property owner as opposed to within the public right-of-way? You mentioned you had a conversation with the township engineer.
He did not want that. Yeah, I was at the meeting this morning.
Okay.
And he did not want that device within the township right-of-way,
What was the reason for that?
because the township doesn't want to take care of it or doesn't want to deal with it.
Okay. So did you have DEP approval prior to that conversation or post-conversation?
We had DEP approval prior to that conversation.
So they have not approved then the device being on the residential property?
We would obviously have to resubmit the revised plans, and they would have to review them and approve them. That's correct.
Well, we actually had it, we did have the one device there's 2 sets of them, one at this low end, then we have a high point in the property that drains this way. So there was a set of devices that was moved onto private land here that the DNR Canal Commission has seen. We left this one in the public right-of-way just because it seemed, practical to have it at the low point and treat all the road. It was only because we kind of really were stuck between a rock and a hard spot trying to satisfy the water quality, but then also moving it out of the right-of-way that we came up with this other solution of moving it up to here.
And so you're still leaving a portion of the road untreated?
Right. That's this portion, and then we'll treat a portion of the road that exists today. So you're treating something that you didn't have to treat, and you're not treating something that you should have treated, so the weighted average is equivalent. That's
Except the
that's
impact on the
done.
property owner,
Well,
by
moving
moving.
the device. We have to move the device.
which has not been approved by DEP, correct?
That's not a DEP issue. The DEP issue is, do we deal with the water quality and stormwater management?
Correct.
How it's paid for is not their concern.
But as designed, it hasn't been approved, right?
The new location has not been approved, that's
Okay.
correct.
All right.
Yeah, I understand the constraints, because you have to do this, and Peter, I have absolutely no doubt that the devices will work as intended. And the township is saying, we don't want to maintain them, so you have no choice but to put them on private property. Then the question becomes, how do you deal with it, and what role can the board have in shaping how you deal with it? And I don't know, maybe that's as limited as you say it is, and I mean, I'd like to see it done through a homeowners association, just because I don't believe that, somebody can have the deed and not actually do it, or what if they, stumble on hard times and they could afford it when they bought the house and then they all of a sudden can't afford it. Or a situation arises where they try to sell the house and it's almost unsaleable because, somebody else doesn't want to do that. I hate to box somebody in like that, but.
There is another, the intersection, the project on Bennett's Lane that Rick Rosso built at the Jeremy Court. There's 8 houses on that.
And that actually is a relevant comparable to something else that's in this report that I'll ask for later.
That one I believe has an underground basin and a mechanical treatment device.
And who maintains it?
No, it's on one of the lots in an easement.
Okay. Again, who
Yeah,
maintains it?
Yeah, I thought that in that case, as I recall, and I didn't do the engineering for it, I did the engineering after it was approved and through construction, that there actually was agreement with the township and a contribution to the township, and the township is responsible for the perpetual maintenance. That's what I recall. There was some kind of formula, that was put together for that.
And quite frankly, Mr. Orsini, one of the things that I did propose to Mr. Zelnick was that, if the township was that concerned, we'd make a contribution, we'd put the systems in, and if he was concerned about maintenance, we'd make a contribution to the township to maintain them if that's your concern. He didn't seem to be inclined to do that, but that's another solution.
Mm-hmm. Ted?
Yeah, I was just going to say that I know we have cases where the developer installs a detention basin and then makes an agreement with the township where they pay for, I think it's essentially 24 years worth of maintenance up front, and after that the township maintains it. And I think that's what should be done, at least with these mechanical treatment devices, because what I foresee happening is one of two things. Either the real estate agent tells the prospective buyer about this obligation, and the buyer shies away and says, hell no, I don't want to get involved with that. Or the real estate agent doesn't tell the prospective buyer, and he doesn't know about it until his lawyer examines the deed and finds this stuff in it, and by this time he's so committed to the project that he goes ahead, but he curses the developer out. I think it would be much better for the mechanical treatment devices, and it would be much more assuring their maintenance if they were installed on the township right-of-way and you prepaid for the maintenance of them, as has been the case with detention basins.
And I raised that this morning as a possibility, and I'd be willing to, I think we can agree that to either do it that way or in the alternative to form a homeowners association, one or the other, so that we don't put the burden on the two.
We have had homeowners associations who came to the town begging to go into this arrangement to essentially pay the township to take over their detention basin. So, and a further problem, particularly with a small homeowners association, is if 2 or 3 people don't pay their dues, then there's that much more burden on the other 3 or 4. So I really see a problem putting it on a homeowners association. I think, I will say, I praise you for having swales, which I assume will be grassed along the side of the street. That is the coming thing that we are supposed to ask for, and for having permeably paved driveways. Again, these are ways that reduce the quantity of runoff and improve the quality of the runoff. I'm sorry if they don't do it enough that you also have to have the mechanical devices. But
Well, interestingly enough, Dr. Chase, if we in fact do pay the municipality to maintain them and we enter into a developer's agreement, then probably there's no reason to move it onto the private lot. We could put it where we had it originally.
oh, exactly.
Right.
Well, I would
Exactly.
think that's something you want to talk about with engineering, because they may still want it out of the right-of-way, perhaps on the private property in the drainage easement. They may want, I don't know if Carl, if you
Well,
have an
they're
opinion
big-
on that, but.
Well, at the end of
Again,
the
I-
day, it's the board's decision, right? It's advice and consent of engineering, but it's the board's decision.
I mean,
Usually, structures like that, they would like, engineering would recommend be out of the right-of-way.
the reason, again, Mr. Hilly, I was at the meeting this morning, he wanted it out of the right-of-way was the maintenance issue more than because it's in the right-of-way.
Let's use the analogy of stormwater basins are usually not in the right-of-way. They're
Right.
usually in an easement on somebody's property.
Oh, yeah.
Again, we could do either. And we can leave that up to the engineering department.
Well, that sounds like some progress.
What I'm here for.
Well, it's more complicated than it needs to be, but it's not all your fault. All right, let's
Just
go
mostly.
ahead with the rest.
Very briefly, with respect to the other staff reports, the only other major, there are two other issues that I just want to discuss very briefly. John House in his report requested that the right-of-way, which you indicated was going to be 20 feet, which was in fact compliant with the RSIS standards, he wanted the right-of-way to be 24 feet wide.
Right.
Can we do that?
We can do that.
And can we still deal with the stormwater management issues that we just went through with the wider right-of-way?
Yes.
Okay. Mr. Healy's major concern was with respect to the trees that we are reforesting. And I assume you have no problem sitting down with Mr. Healy to review where the plantings are to make sure he's satisfied that it doesn't look like we just put straight lines of trees down?
Yes.
And also discuss the species of trees, is that
Correct.
okay? And
Peter, before you leave Mark's report, so you mentioned Jeremy Court, so I'll go back to that. So I believe we erred, given that Mayor Kramer has gotten a few calls about streetlights. So for some reason, they were not installed, or we didn't require them to be installed on Jeremy. I think we should have them here.
Yeah, there's an existing utility pole right where Ruth Street will come out to Elizabeth Avenue that's being relocated that has a light on it already, so that intersection would be lit. We don't propose any other lighting, but is the board inclined
What
to
about
ask
Ruth
for?
and Madison? Is that going to be lit?
Well, that's what I was just going to say, is there something that you would want to, again, a utility pole mounted fixture at the intersection of Madison and Ruth?
Yeah, that would be
Yes.
good. At
And
least
LED.
And that would be, yeah, PSE&G now typically uses the more efficient LED lights.
At least the development would be bookended by two streetlights, which is, it's not
Yes.
as long as Jeremy Court, but, yeah, I don't want to put us in that situation.
But no other lights along the road.
I think one in the middle.
Yeah, wouldn't mind that.
Right now, I'm not sure that there's, how's power? Power would be, right now, there's no overhead utilities in Ruth, so it would be underground through the property, and we'd have one pole.
Not an issue.
Right.
That's the way it is where I
Okay.
live. Nothing's above ground.
Right.
Curbs and sidewalks you want waiver for?
waiver.
Yeah.
Right. Yeah, there was a suggestion, we put in 30-foot wide cartway with curbs and sidewalks.
Well, the curbs would
And we're not-
obviously defeat the whole purpose of the swale thing going on, so I'm not, I don't have a problem with that. And
Okay.
sidewalks, I mean.
I think we should have sidewalks, though, because this area is developing, and you're going to be having children, and I can see in the future, as that area develops, maybe even a school will have to go in. We need to start somewhere.
My suggestion would be that we have preferably a 26-foot wide cartway, but then a stripe setting off a bicycle lane on one side and no parking on that side. I think probably you really should, yeah, your original suggestion, 20 feet, somebody commented no parking on either side.
Correct.
But if you have, and this is complete streets type thing, which I'm supposed to be working on for the township, if we have this as a bikeway, and it would also be a pedestrian walkway, but it would not cut off the street from the bioswale, so that the street would still, the runoff would still go into the bioswale with the advantages for purification that way. And it wouldn't, it would give a somewhat protected place for people to walk without the negative aspects of the curbs.
If I may, I'm not going to argue for a curve, but I would argue for a sidewalk on one side. And the reason being, your suggestion for a bikeway which could also serve pedestrians is fine, except in the winter when it's going to be covered with snow, and you still would have school during the winter.
No.
And then the question is, where is the school bus going? Probably down Elizabeth Avenue. So there would probably be a need for potential children to be able to get to Elizabeth Avenue.
Be aware, if we are putting sidewalks either on one side or both sides, we are not putting sidewalks to Elizabeth Avenue because our property doesn't go to Elizabeth Avenue.
I'm aware of that, but every time I go down Churchill Avenue, I sort of wince that we didn't require sidewalks on Churchill Avenue because it is heavily traveled, and even where there would have been sidewalks with the new development, it would have been a help to the school children. Yep.
Well, what do we advise them? I'm fine with one sidewalk on one side, you know. I don't think it needs to be on both. It's not going to get you all the way to Elizabeth, but it'll get you close enough, I guess.
If we put it on the more northerly side, it would get closer to Elizabeth.
Mm-hmm.
But then intruding into the wetland buffer.
Can that be done?
When we have a wetlands issue on that side, hang on.
Well, if you have pervious sidewalk.
I think that the stormwater management features, like the roadside grass swales, have their benefits. They also take up much more space than like a curb and gutter, so that takes up a good chunk of the real estate within the public right-of-way. This might be a sidewalk. It would have to be maybe even within an easement just beyond the right-of-way on the private lots, so that we don't disturb those swales. That would get it further away from the paved road, and it looks like that we'd have to, we have a pending DEP permit for wetland transition area averaging that we may have to modify to allow the sidewalk in front of that portion of that corner lot where the wetlands are, or perhaps, or move it to the other side, or bring it closer to the road.
Yeah, that's what I was worrying. That's what I was worrying about.
Yeah, it would be easier on the other side. The wetlands aren't there on that corner lot.
I wanted also to comment on the reforestation. Much as Mr. Healy said, the trees should not be in these orderly rows. I would say you ought to put in fewer trees, but also put in some understory shrubbery such as spice bush to make a more natural forest there. Probably would come in eventually, but you have to stay ahead of the multiflora rows. In fact, I would be willing to credit you with one tree for every 3 spice bush you put in. Because I'm sure you're thinking, well, the more trees we put in, the fewer we have to pay the trust fund for.
Again, we can work that out with Mr. Healy, and we'll accept your recommendation and resolve that.
Any other staff report issues that you'd like to raise?
I think we've hit them all, did we not, Mr. Ford? Everything else
Yes.
we can comply with?
Yes.
There was just one other comment, and for the record, the engineering report indicated that we needed to submit an environmental impact statement. That was in fact submitted as part of our original submission, and it should be in the board's file.
Yeah, we have it.
Mike, question? There's no other stormwater series facility that could be designed in order to get your required TSS removal? That would be outside the right-of-way? Get your 95%?
Yeah, we're taking advantage of just about every on the list, you know, the grass swales, the mechanical treatment devices, so we really don't.
Could use like a bioretention, maybe with a manufacturer, depending on the size of the bioretention.
Well, that,
Get
like,
90%.
because of the heightened requirement, there's no single device that you can, so you
Oh, I'm
always
not
have to
saying a
add
single
another one.
device. You have to have multiple devices.
Right,
Yeah.
right.
In series. Is it possible?
We actually have an application now that has a basin plus a mechanical treatment device on the outlet of the basin. Right.
That would get the
To get to the
required
95, correct.
95. So
Right.
it can be done other than having facilities within the township right away. You may have something in someone's backyard, but depending on the grading and everything, you could do it here.
Well, and the trouble with this one is that would maybe handle the western portion of the site, but the eastern portion of the site with that Ruth coming out to Elizabeth, you really only have you don't have a place for a basin there. We don't own any land on the downslope side.
Again, you're doing a trade-off on Madison, which would drain towards.
For a portion of that,
Yeah.
but we're not, only the portion that doesn't get to that mechanical treatment device because we're relocating it, right.
But it could be possible.
For that portion, I don't know, there's not a spot for a basin there. It's not like we could put one in.
Mr. Orsini, I just want to make one other comment that we sort of didn't touch on. There was reference to the ability of bringing public water to the subject property. There is no public water immediately available in front of this property either or on Elizabeth Avenue in the vicinity of the intersection of our proposed street. American Water has water somewhere in that area. We're investigating it. If it's feasible, we may be able to bring it in, but our plan was designed with the wells. If we can accommodate public water, we will, but first of all, there's no requirement that we do, but if we can accommodate it, we will. And just for the record, if we get public water, then we can get 10,000 square foot lots.
Smaller houses.
Mm-hmm.
But you have to come back to us.
Right, yeah.
And I'm sure you'll be happy to see me again.
You always are. Other board questions? Are you through with the
I
testimony?
am through with my testimony.
Any other board questions for Mr. Ford or Mr. Lanfret?
One question, Mr. Chairman.
Yeah.
So the stormwater approach, to sum it up, is the swales, these mechanical treatment devices. The reforestation is part, basically, of the stormwater plan, because you're replacing lawn with forest and has lower runoff coefficients, correct?
Correct.
And the on the individual lots, all the driveways are pervious?
Correct.
Okay. So is the timing of the development, I'm assuming that the first phase of the development is going to be to construct the road and all the associated stormwater facilities? That's the first phase?
Yeah, I mean, I would say, just like what you just described, the driveways handle the driveways themselves, so they wouldn't have to go in until the house goes in and then the driveway goes in. But yes, like the collection system within the road, the swales, the mechanical treatment devices, even the reforestation
That was going to be my next question.
is
'cause
part of,
That would have to
right.
happen in the initial construction. That can't be left to the individual construction of those individual lots, because it's part of your stormwater.
for the
approach.
road, correctly.
Okay. And is
Correct.
that reforestation area in any type of conservation easement? What's to
It gets deed
prevent the
restricted.
next homeowner
It's-
from coming in and clearing it?
Deed restricted.
Correct.
DEP requirement.
Right.
Okay,
That was in one of the reports.
okay. And then is there anything to prevent a future homeowner from tearing up the pervious pavement and putting in normal pavement?
That's also deed restricted.
Correct.
And be in their deed?
Right.
Okay, all right, thank you for answering that.
As if anybody's going to be able to enforce that.
Well, there's the sheriff sitting at the end of the bench there. So I am sure if Mr. Houck sees somebody repaving their driveway on Ruth Street, he'll be out there with the police or whatever, and
Well, I do believe the
SWAT team.
township
Pervious
requires,
police.
Ted, I do believe the township requires a permit.
Yeah.
To even to do over existing paving, right? If you have a paved driveway and you're just gonna repave it, I don't know whether there's an
That's true.
inspection
We
about it.
require a
hard- that's
permit
hard
for
to-
everything.
So that
As
should,
years go on, that's hard to catch.
that should flag you somehow. But I
It
guess-
would be caught in one of the quarterly inspections, if it, usually typically pave over the spring, summer months into the fall. And one of those inspections would have picked up that, hey, it's not a normal.
And I can actually say, I had a client who had a conservation easement on their property, residential property, and I don't know how the DEP found out about it, but they had clear cut it, and they came back in, and they made them replant the entire thing to the tune of a couple $1,000s. So, I mean, they do monitor these things. While you may not believe they do, they do show up, they find out about them, and they enforce them.
Well, we just had one ourselves on Girard Avenue and
All
near
right.
Hamilton Street.
Let's open to the public on this one.
Make a motion to open to the public at this time.
Second?
All in favor?
Aye.
Anybody from the public wishing to comment on this application can please come forward.
Seeing no one come forward, a move to close it to the public.
Second?
All in favor?
Aye.
I would respectfully request that the subdivision be granted the one bulk variance for the 5-foot frontage deviation for the one corner lot be granted. As a matter of fact, Mr. Healy, it probably would make sense if the town vacated the rest of that portion of Madison Road, Madison, because it goes nowhere, and then that variance would actually be eliminated. That's something you may want to look into.
You also have the what do you call it, through lots as well.
And the through lot variance, and again, we would have no problem putting language in there. There would be no access through to the rear portion of those through lots.
Yeah, we should do that. So C1?
Well, I'll make a motion to approve the application, but I'm not sure what we decided with the mechanical devices.
I think the two open questions are the sidewalk. I don't believe there was decided
Well,
whether it
I
was the
think-
northerly or southerly side. And then the second question, I believe, is whether you want to recommend that the township accept the responsibility of taking care of these mechanical treatment devices with the applicant paying some type of, kind of following our existing ordinance, but they have to come up with a fee for the long-term maintenance costs. And now I'd have to take into account the fact that these particular devices have, is it quarterly inspections, and is it biannual switching over of the,
The cartridges are based on the manufacturer's recommendation.
and I think the formula is based on a 30-year cost. Is that
I
right?
think
26.
that's the
20,
most
26?
reasonable
26-year.
way to handle it. And there would have to be an easement on the homeowner's property for the location of the device, that it would not be in the right-of-way. It would be out of the right-of-way, and there'd be an easement for the device. And I think you said 24 years
26, right?
payment required. And as far as the sidewalk, that it be on the southerly side,
Did you say you couldn't do northerly because of the wetlands?
yes,
It would be more problematic, correct?
that the sidewalk be on the southerly side.
And the 3 streetlights too.
And yes, three street lights, LED lights. That's the motion.
I'll second.
And how wide is the pavement going to be?
24, that was in compliance with the staff reports.
24 feet is what
24.
they said they would do.
That be no parking on both sides?
And that was up from 20, right?
Correct.
What was the reason to go to 24?
The fire wanted it, again, RSIS provides for 20. It's up to the board. I mean, if they want 20, we'll be happy to put 20, but
24 with street signs stating no street parking allowed.
Yeah, the difference between a 24-foot cartway and a 20 in terms of people speeding greatly increases. So I'm in favor of the 20 because I think it makes for a much safer street, considering that you're only going to have a portion of a sidewalk in this residential community. So there is a visible difference that leads to speed when it goes from a 20 to a 24. So I think the 20 was reasonable and the best design for this block.
But it was the fire department that wanted the 24 for the fire.
Yeah, but there is no on-street parking, so they have 20 feet of cartway to maneuver.
Well,
The
it's not-
fire
it's not-
department-
yes, yeah, sorry, Ted.
Aerial truck operation.
In other, I mean, other, say, around commercial buildings, the fire department frequently asks for 24 feet, even if there's no parking in a roadway going around a commercial building.
The reason is so they could get the outriggers of the fire truck on pavement.
Yeah.
20 feet will not allow that to happen.
I have no problem with 24. I mean, where are you going to go? Look at this street. Does it look like a drag strip?
again, I don't care. We said we do it, and that's fine.
We didn't.
As long as it doesn't connect to Array Drive.
We're in the, we're in the motion. The motion's made. I seconded it. Let's vote on it. We're not chucking on amendment.
Councilman Chase,
Yes,
Laurel Hauk,
Yes.
Cecile McIver,
Yes.
Robert Mettler,
Yes.
Safa Mansray,
Yes.
Charles Brown.
What are my options? Yes, no, or abstain?
Yes.
I
Those are your
abstain.
options.
Um,
And Chairman Orsini.
Yes.
Mr. Chairman,
Yes, Bob.
the only thing, this has been done, so I'm not trying to change anything.
Okay.
But the only thing that worries me really is the no parking on either side of the street. I can't see that people are going to comply with that. If in these houses you have sometimes people with 4 cars, and can they put them all in the driveway? And what if they have a party? And I really wonder if that is going to work, but that's all.
Duly noted.
Thank you very much.
All right.
enough to discourage people developing in that area.
I assume you're back for part 2, right? Yeah, you got the next one?
And I don't need a break.
All right. Well, if you do, tell me now.
Oh, boy. He may or may not let you.
All right, so, the next application is Devon Realty, PLN 17-00010.
Good evening, Mr. Chairman, members of the board. Peter Lanford appearing on behalf of the applicant. This is also a sort of recycled application. In 2013, under docket number PLN 13-00011, we appear before the board to construct a parking lot for parking of tractors and trailers on the subject property. The board approved that application in 2013, And as a result of that application, we did site clearing on the property. After the property was cleared, the applicant has decided to, in fact, construct a warehouse, and that's what we are here for this evening, is the construction of a warehouse building. I do have with me this evening Mr. Muller from Dynamic Engineering and Mr. Menino, who is the architect. I believe I can probably get all of my, and also Mr. O'Brien, the professional planner, since we are seeking one variance, which is a variance for impervious coverage. I think I can get all of my testimony covered with Mr. Muller and Mr. O'Brien, so I will have Mr. Muller brought up and be sworn.
You swear the testimony you're going to provide is the truth, the whole truth, and nothing but the truth. If you could state your name, spell your name for the record, and provide your address.
Thomas Muller, M-U-L-L-E-R, Dynamic Engineering Consultants, P.C., 1904 Main Street, Lake Como, New Jersey, 07719.
Mr. Muller, are you a licensed professional engineer in the state of New Jersey?
Yes, I am.
And for how long have you been so licensed?
About 3 years.
Can you give the board briefly your education?
That's all right, as long as he's certified in the state of New Jersey.
I appreciate it, Mr. Chairman. Thank you.
Okay, as a matter of fact, you were here and your firm, you were involved in the presentation of the RPM application about 2 months ago.
Yep, I'm very familiar with this room. First opportunity before this board, but I am very familiar with the building.
Okay. Mr. Muller, your firm prepared the site plan, which is the subject of this application, is that correct?
That's correct.
Okay, and we're going to rely on certain exhibits this evening, and you presenting your testimony?
Yes.
And unlike Mr. Ford, who was Mr. High Tech, you were back to low tech with your application?
Yes, I am.
All right, can you indicate what exhibits we're going to rely on, and we can have them marked?
Sure. I will reference the survey that was submitted as part of the application. I'm not sure if you want to mark this as...
This was submitted, we don't need to mark it.
Okay.
Pete, if that was part of the packet, we don't.
It was.
Yeah. That's new.
Yeah, this is the aerial exhibit prepared by our office dated July 19th, 2017. Essentially just a colorized version of sheet 2 of the site plan set.
We can mark that with A1 with today's date, which is the 19th.
Exhibit A2 would be the site plan rendering, which is a colorized version of the site plan layout with the landscaping turned on with colorized hatches to indicate different service types. And then Exhibit A3 would be the colorized architectural elevations prepared by Sermonera Architect, dated July 19th, 2017.
Thank you, Mr. Muller. All right, Mr. Muller, briefly, what's out there today? And if you want to refer to Exhibit A2?
Sure.
Or A1, I'm sorry.
All right, so the property is identified as 60 Clyde Road, Block 86.02, Lot 1.03. The total lot area is 9.14 acres. It's generally rectangular in shape. It's currently zoned in the M2 Light Manufacturing District. All properties surrounding it within 200 feet are also located in the M2 district. In addition to that, all of the properties around it are also light manufacturing uses, very similar to the existing condition as well as what we are proposing. Just referring to Exhibit A1, the subject parcel is located in the center of the site. It does have frontage on the public right-of-way of Clyde Road, which is on the east side of the site, which is on your left side of this exhibit. There's also frontage on Jiffy Road. It's a little bit of a unique situation. Board might recall from our 2013 application. The actual Jiffy Road right-of-way is a dead end at our property along the western property line. as it continues through the site, it's actually a private right-of-way easement, 50 feet wide. So the applicant has full control over that easement. It's not a township-owned road.
Okay, and at the present time, there is one structure on the subject property,
Correct.
and approximately how large is that structure?
It's 100,800 square feet, of which 2,650 square feet are office and the remainder is warehouse. There is what you see on this aerial exhibit A1, the existing western portion of the site was wooded. That is the area that we are proposing to redevelop. As part of the 2013 approval, this board did grant the applicant the approval to clear that area for the previously proposed improvements. Since then, the applicant did proceed with clearing that area and roughly grading it. However, they suspended those construction activities since then, and that's why we're here tonight.
Okay, and in conjunction with the previous approval, there were, as you can see, numerous trees that had to be removed, and all the payment of all fees for tree removal have been satisfied with the municipality, correct?
That's correct.
Okay. All right, let's indicate to the board why we're here tonight. What are we doing?
Just referring to Exhibit A2 now, I do have some reduced size renderings just for the board so you can see it a little better. Thank you. So we're here tonight proposing a new freestanding warehouse structure. The size would be 55,900 square feet, which would be located on the western portion of the site where the previous approval was granted. Inclusive of that 55,900 square feet would be 3,000 square feet of office, and the remainder would be warehouse. In terms of zoning and bulk requirements, it complies with all your setback requirements, building coverage requirements, floor area ratio. We are seeking one variance for this application, which would be the total impervious coverage on site, which I'll touch on in a little bit. There is an existing parking variance due to the existing size of the parking stalls, which is going to be eliminated as part of this application. And there's also an existing non-conforming condition for the existing building with respect to the front yard setback to Clyde Road. Under existing conditions, it's 48.8 feet. That condition will remain under post-development, however, it's not exacerbated as part of our development. I'll just touch quickly on the architectural design of the building. Referring to Exhibit A3, this is a colorized rendering of the elevations of the building. It's a modern architectural design. There are a number of colors incorporated into this design, which is what you're starting to see a lot in modern warehouse design. The building height is 44 feet. Whereas the ordinance requires a maximum of 50 feet, so we are compliant in that regard. The main portion of the building will be a medium beige color with a light beige accent band around all four sides of the building. There'll be darker beige areas centered along the two entrances to the building on either side, as well as along the bottom portion of the building. This building will be precast slab. It won't be your standard CMU concrete building. It's basically an upgrade from what you typically might see. Along the frontage of the building, which is indicated as the east elevation on the bottom of this exhibit, we do have two isolated entrances, one on either side of the building. That is being provided in the event that two tenants are in this building. Similarly, a symmetrical design was provided for 4 current loading positions as well as 2 drive-in ramps. And we do provide a provision for the potential for 4 knockout walls to provide an additional 4 loading docks depending on the tenant's needs in the future. We will be providing signage on the building, which would be completely compliant to the land use ordinance. Just to head back to the site plan, referencing Exhibit A2. In terms of parking, the ordinance requires 98 parking stalls for this building. I'm sorry, 90 parking stalls for this building. We are providing 98, which exceeds the ordinance requirement. Ordinance requires 9 by 18 parking, which we are providing. We are providing additional ADA parking to bring the site into ADA compliance. The parking areas have been located strategically throughout the site for the potential tenants for this building. We are reorganizing the parking area on the northeast corner of the existing building. We're providing another isolated parking area on the northwest corner of the existing building. And then we're providing 2 independent parking areas centered on the 2 front entrances for the proposed building. Again, for a total of 98 total parking stalls.
So given that it's a warehouse, do you need that much parking, or are you only doing it because it's ordinance?
We don't know who the tenant's going to be in the future, so we are providing it to comply with the ordinance, and it is a typical number of parking stalls you would see for this type of development. I would like to note as
Yep.
well,
I know what Mr. Orsini is driving at, that he would prefer that we bank some. However, again, given the fact that we don't know who's going to be there, I mean, I assume if you want us to go down to the zone requirement of 90, we can probably pull 8 out, but I don't want to go below 90 because, again, we don't know who the users are.
I'm just looking to, I mean, you have a fairly minimal increase in impervious coverage, which is your only variance, but, you know, anything you can do to get lower is a good thing if you don't need it. I mean, if you feel you need it, then it's in compliance.
Yeah,
and
we
it's,
could take the 8 out, and obviously it would reduce the impervious. The rest of them, I'd hate to say we're going to take them out and then go back and put them back in. If we knew who the user was, and with certainty we can say we will never need them, and then it makes my job simpler, and we can say we could take out spaces. But here it's a spec building with no user right now. So I think I'd rather err on the side of having adequate parking than not having adequate parking.
okay.
Mr.
But
Chairman?
if you can go to 90, then that's fine. Yeah.
The ordinance allows them to bank up to 50%. Perhaps you could have a condition in the resolution that says if they get a tenant and that tenant doesn't need the spaces, that they can adjust the net amount of parking during construction.
I mean, if you,
Yeah,
I don't
I mean,
know
you
what-
could put, the problem's going to be, most of the time, you're not going to get a tenant until the building's up. And then,
Okay.
I mean, again, if we can take out some parking spaces, I understand the board's intent. If we can show more than 8 spaces.
Thought was to give you the flexibility if it wasn't needed to
Yeah,
reduce. but that's-
I understand, Mr. Healy. Like I said, if there's a way we can take out more, we will take out more. We will agree to remove 8. And if we find that we don't need the rest of them, we will notify, I guess you are now the zoning officer, that we may revise our plans to take out additional parking spaces if we don't need them and bank them.
Okay, sounds good.
I do want to point out that we will be milling and overlaying the existing loading area in front of the current building, just to upgrade it, to clean it up, and just to make some repairs.
How about the Jiffy Road itself, which is in terrible condition?
That will remain as the existing pavement. This board did approve the 2013 application with no requirement to improve Jiffy Road. It is a private easement. It isn't open to the public, so the applicant is currently proposing to leave it as is.
I mean, obviously.
Oh, isn't the applicant the owner of Jiffy Road in this stretch?
Yes.
And they're going to leave it in that mess?
The board commonly, even if it's a shopping center that has, or something like that, that has poor pavement conditions, the board will require them to fix it. Part of their site plan.
We will upgrade to make, you know, the road does need some fixing. It will be.
I think as a matter of business rather than a matter of board requirements that you ought to do that. I mean, I went and looked at it today. That's how I comment. And I also note that there are signs at either end saying that this is a private way.
And it is a private way, but again, we will patch or repair as needed that existing portion of Jiffy Road. We can put a note on the plan.
You don't want anybody busting an axle, you know? Bad for business.
unless it's somebody who's on there that's not supposed to be there.
The township numerous times gets complaints regarding the condition of that easement section of Jiffy Road, and being that there is a street sign on the Clyde Road side, they think it is the township road, so bear the brunt of the complaints, and we forward them on accordingly.
Yeah, and you know, not to belabor this issue, because we will fix it. In 2013, we offered that portion of Jiffy Road to the township so that they can take care of it and properly maintain it, and they rejected it. So, and if you want to take off the Jiffy Road sign on Clyde Road, I don't have a problem doing that because it probably doesn't belong there.
That's a good point.
The reason for that, the town didn't want to take it, is because of the loading dock and other areas which weren't in compliance with any kind of standard onto a township, future township right-of-way.
But anyway, if you want to remove the sign to deter people from using it who shouldn't be using it, it could be gone. It's not our sign.
And there is a sign at that end that says private road, or
Yes,
no?
at
it says
either end.
At either end, both ends?
Yes.
Yeah.
Jiffy Road by Clyde.
Just to touch on access and circulation while we're on this point, we aren't changing the access onto the easement from Clyde Road or Jiffy Road. However, we are cleaning up the access from the proposed parking areas onto the easement area. Under existing conditions, I'm sure the board's aware that it's a little bit of a free-for-all. We are cleaning it up. We're choking it down to standard driveways as if Jiffy Road was a public right-of-way. On that same point, we met with the township professionals a number of times over the last few years to establish the plan that you see today. One of the main concerns of your fire marshal was that we provide a paved access road around the entirety of the building. So what you see here today is that 360-degree circulation throughout the entire site around the proposed building to satisfy that request.
And it ought to be 24 feet all the way around.
Yeah, I would like to note that Mr. House, your fire marshal, did note that in his report. We will work with him to satisfy his request.
That's probably going to change that'll increase the impervious surface also.
Exactly. We're currently proposing 68.8% impervious. That number will go up after we have our discussions with Mr. House.
Yeah, but I think fire safety is always more important than percent impervious surface.
Just to touch on stormwater management briefly, we are designing this development in compliance with all state, county, and local requirements, including the Delaware and Raritan Canal Commission. The proposed design will have two independent storm systems. One will be an above-ground basin to the rear of the site, which would be the south, and one would be an underground system to the north of the site, both of which are required to meet state and local requirements. All utilities are available through public connections along Clyde Road and through the Jiffy Road easement. All electrical and communication lines will be underground. You won't see lines strung between utility poles like you might see in some warehouses. Everything will be installed underground.
Will all lighting be LED?
Yes, I was just going to touch on that. Actually, we currently propose metal halide. However, the board planner requested LED, and the applicant would be happy to provide LED. There was another comment from the board planner regarding the uniformity ratios that we are currently proposing. We're slightly above what the township prefers. We will revise the lighting plan to show LED lighting and to bring those uniformity ratios down.
All right. Mr. Mueller, before we go into more detail with respect to the reports, there are some wetlands on this property, correct?
Correct.
Where are they?
The wetlands are located on the western portion of the property, which was essentially the undeveloped portion. We do have DEP approval to fill those wetlands. They're very small pockets of wetlands, so we do have those appropriate approvals, and they're still current.
Okay. All right. Now, one other issue, which is in the staff reports, but the general issue, how are we handling trash with the new building?
Sure. We currently have two dedicated trash enclosures located in the rear notch of the building, which would be the south notch of the building. The fire marshal did request a 10-foot setback from the building, so what we will do is relocate those trash enclosures away from the building to comply with that 10-foot requirement. We'll likely move it back to the rear aisle along the back of the building, so trash and refuse vehicles could still adequately access it and will also meet that setback requirement.
Now, you've had an opportunity to review the staff reports that were generated in conjunction with this application.
Yes, I did.
All right, I just want you to comment, Mr. Healy's report is basically 3 pages, and the one question that he raised was why we are only proposing curbing on certain portions of the parking lot and the ring road along Jiffy Road. Can you respond to that?
Just to identify the areas that we are not providing curbing. In the proposed area, we are not providing curbing along the rear of the drive aisle. The purpose of that is for stormwater management purposes to sheet flow water conveyance into that above-ground basin. It's considered a low-impact development technique that the Delaware and Raritan Canal Commission prefers. We also are not providing curbing along the eastern edge of the proposed parking in front of the existing building. For one, it wouldn't be required as it's not a drainage issue. It's an existing condition. There's no reason to have curb there. It's not protecting the building or anything like that. And then again, on Jiffy Road, we are maintaining the existing curbing patterns there. We are proposing some curbing where we need to create those driveways. However, we are keeping the edge of pavement as is.
Have you had an opportunity to review the report of Mr. Zelnick dated July 12, 2017?
Yes, I did.
And that report has, again, 5 pages. Other than item number 18, do we have any problem complying with respect to any of the other comments within the report?
I would like to touch on comment number 18 and comment number 22.
All right.
Just regarding comment number 18, the board engineer requests that we relocate the underground detention basin out of the loading area. If the board permits, I would like to just keep that as a condition of approval, that we could work with the board engineer. We are comfortable with where it's designed. It's an underground basin with adequate cover. It is concrete pipe. It is underneath the loading area. However, we are specifying a significantly thicker pavement section over it for additional protection. What we have proposed is much more typical of what you would see instead of essentially splitting it into 2 basins underneath the parking area. So unless the board has any other issues with that, I think we would work with the engineer on that one.
Okay. And item 22?
Item 22, the board engineer requests a 4-foot fence around the basin perimeter. Again, we don't feel this would be necessary as the basin would be dry most of the year. It's designed to drain within much less than 3 days. It is only about 3 or 4 feet deep. There would be no pedestrian traffic in that back area, which you would typically see a requirement for fencing in that situation. However, this is only vehicular. A fencing wouldn't do much in terms of preventing people from entering that basin. So we prefer to keep the fencing out at this point as it's a maintenance issue, but unless the board has any issue with that, we would.
Also, is the basin visible from the roadway or,
No,
or from Jiffy Road?
It would not be.
And are there any residential dwellings in the immediate vicinity where kids may wander to that detention basin?
No, they're not.
So there is really no need for the fencing, in your
I agree.
opinion? Thank you. And other than that, all of the other staff reports and other comments we can comply with, correct?
That's correct.
Thank you. I have no further questions of this witness.
Do you have any other witness?
Well, I need to justify the variance for the impervious coverage, which will hopefully be very quick.
Okay, well, before we, does the board have any questions for this particular witness before? Yeah, Carl.
Regarding the underground detention basin, I kind of agree with Tom Zelnick that underground basins for access and maintenance, whether it be future maintenance or something happen, should be in parking areas rather than in a loading dock with ramps and guardrails and retaining walls above them. I mean, looking at it, is it possible that it could be split between the two front parking areas?
I would have to run those calculations, but I would assume it is
Possible.
maybe possible, right?
Right, okay. One other question, number 20 from the engineer's report also, regarding the geotech and the watertight basin. Yes, it's in the groundwater area, seasonal high area.
Correct.
What would be happening to make that watertight? Because concrete pipes are not typically watertight.
What I'll
with
do is
cement.
provide a specification on a watertight joint that we've used many times in the past that has worked for this type of situation.
Gasket in the.
Yeah, it's a
pipe.
gasket. It's not a standard connection. It would be something that we're upgrading for this basin. I would like to just touch base on your comment. All the maintenance manholes for the underground basin are located outside of the loading area. They're all located within the parking areas. So in terms of maintenance, we're not going to be disrupting the loading activities. It'll all be within the parking areas. Okay.
Okay, if there are no other questions of this witness, of course, we remain sworn in, so we can go back if we need to. Your next one.
Mr. O'Brien.
Mr. Chairman, just quickly in the meantime, I just wanted to make one note, which is that the site plan does have one feature that we ordinarily wouldn't permit, but there's a little bit different circumstance here. Both the existing warehouse and the proposed warehouse have the loading docks basically facing the road, and the trucks would be maneuvering in quote-unquote the road to access the buildings. That's not a situation we would ever normally allow, but technically this is not a public road. This is the private road on private property with an easement. So I just want to make that clarification for the record so that this isn't in any way setting a precedent for future light industrial developments. This is normally not a situation where we would allow.
Good point. Thanks.
And that's why the town didn't accept the road back in the previous application in 2012 or 14.
Makes sense.
Good evening. Do you swear the testimony you're going to provide is the truth, whole truth, and nothing but the truth?
I do.
If you could state your name, spell your name for the record, and give us your address, please.
Kevin O'Brien, O-B-R-I-E-N. My address is Madison House, Suite B, Madison Avenue in Rahway, New Jersey.
Mr. O'Brien, you are a licensed professional planner in the state of New Jersey.
I am still so licensed.
Accepted.
Okay.
Thank you, Chairman.
Mr. O'Brien, as indicated by Mr. Muller, when we came in here tonight, we knew that the impervious coverage requirement was 65%. We were asking for 68.8%, but we are now less than 68.8% because we gave up some parking stalls, but we may be above 68.8% if we widen the fire lane as requested by Mr. Chase and also by Mr. House. So I am going to assume for your testimony that the impervious coverage will be somewhere between 67 and 70%, which I think would cover the number. And based on that, can you indicate to the board, why we're here and a planning justification for the grant of the impervious coverage variance?
And I did hear the previous conversation about keeping this short. Since we are only asking for one variance, I think I can sift through a lot of my regular testimony and try to focus just on that particular variance, reserving the right to go back and use whatever other material I need to answer any questions. The prior approval allowed 63.9%, and that was for outside tractor-trailer parking. So we're at 68.8. This evening, we just lost somewhere around 1,266 square feet from the 8 9 by 18 parking spaces. The master plan of the township does encourage commercial and industrial development in established areas. It also asks to locate major employment and traffic drawing uses in areas where they will least impact residential neighborhoods, and I believe this complies with those thoughts of the master plan. This also complies with many of the passages in the land use law, which encourages municipal action supporting the general welfare, securing safety from fire, providing sufficient space for various uses, promoting a desirable visual environment, and encouraging coordination of the various procedures. I believe this application is consistent with those by constructing a conforming warehouse in an area that's suitable for it, and the general welfare is advanced by providing employment, economic activity. As we have also learned this evening through testimony that the applicant will be further maintaining the Jiffy Road easement, which currently serves as a semi-public thoroughfare. I have as A2, I think, an aerial of the area. This is the, yeah.
It's a different aerial than the A4.
Yeah, this shows the current conditions on the ground. The bulk variance requested is for impervious cover, and I believe that that variance can be granted under a C2 argument that the benefits outweigh the detriments. One of the major pushes behind adding impervious cover, did you get one, Mr. Brown?
I did, yes.
Okay.
Yes.
So you're raising your hand.
Oh, no. They were blaming me for the noise, and it was Councilman Chase.
Turning pages,
Sorry, you even asked. Thank you. So in discussing the impervious cover, one of the drivers behind that is the fire road, the access road that goes all the way around the building. That adds impervious cover that takes us over the 65%. That is done at the express wish of the fire marshal to conform with the fire department requirements. The aerial you have in front of you shows the existing warehouse on the right, the lighting factory on the north side of the road, and the cleared out space on the left-hand side within the yellow parameters of this lot to show what had previously been cleared. The Jiffy Road right-of-way ends at the northwest corner of the lot where the yellow lines intersect. So in providing the fire access roadway and increasing impervious cover by enough to push it over the 65%, lowering the parking requirements, which is going to lower impervious cover, then going back to possibly improving some roadway, may very well keep us over, but I think that those are all reasonable aspects to consider in granting this variance, because the benefits of improving the Jiffy Road roadway, keeping the fire access road around the building, which supports not only this property, but as you can see, it affects 3 other buildings behind it and on the side of it as well. In fact, 4 if you include the one on the lot already. I believe that this application promotes the general welfare. It provides jobs. There's going to be 30 to 40 permanent warehouse jobs. There's going to be about 40 construction jobs that are generated by this application during construction, and I believe that this application can be reconciled with the master plan, the zoning ordinance, and I can see no negative impact to any of the neighbors or to the zone plan or the zoning ordinance.
Thank you, Mr. O'Brien.
Any questions for Mr. O'Brien?
Tried to distill that, Mr. Chairman.
I think you did a good job. I'm entertaining a motion to open to the public. Oh, Ted, sorry.
Well, this is really back to Mr. Mueller, but it is on impervious surface. At the rear of the building, there's an area which appears to be paved in the angle between the 2 arms of the L. And I wondered why that is paved and whether you could save impervious surface by not paving it.
We will lose a little bit of impervious. I did note we are relocating those trash enclosures. It is paved up to that point because of those trash enclosures. I'm moving the trash enclosures, so we'll lose that impervious there.
Good.
Mr. Miller,
That
while
might
you're up,
get you under.
the setback, the existing setback, 49.9, is that correct?
48.8.
48.8, okay. So since that's an existing non-conforming situation, I'd suggest that that be, if the board's inclined to approve it, that be added as a variance. Obviously, there's no detriment because it's an existing condition.
I would agree.
Okay, now,
Motion to open to the public at this time?
Second.
all in favor?
Aye.
Anybody wishing to come forward and speak on this application?
Seeing no one coming forward, I would move the public hearing on this application be closed.
Second.
All in favor?
Aye.
So, any last words?
Would respectfully request the site plan be approved with the impervious coverage variance and the variance for the existing condition of the front yard setback for the existing building. And we will comply with all the, and I would still request relief that we do not fence the detention basin.
Motion to approve with the limitations that we discussed.
I have one question, and my question is, we've moved around the impervious coverage, and as an attorney, I always like to have a number, because it makes it kind of hard to say, we're going to give you an impervious coverage variance for a percentage to be named later.
Well,
we will-
it was 67 to
So is there-
70%,
I was gonna
depending
say,
on
is
the
there a number-
engineer.
Is there an upside number that we're comfortable with, that the board would be comfortable with, understanding what's going to happen?
Yeah, I heard 70%.
70.
And that's what I heard too. I just wanted to know if that,
As
Got
an upper.
as an upside.
As an upper limit
Yes.
because
Okay.
of the,
Yeah. My guess is we'll be under it, but 70 works.
Okay.
okay, that's part of the motion.
Okay. And no fence around the detention basin?
And no
Right,
fence
okay.
around the detention.
Okay. I'll second.
Councilman Chase,
Yes.
Carl Hauck,
Yes.
Cecile McIver.
Yes.
Robert Mettler,
Yes.
Mustafa Manzray,
Yes.
Charles Brown,
Yes.
and Chairman Orsini.
Yes.
Thank
So-
you very much.
You're welcome. Before we all run away, we have a couple of work session items, so Mark, I guess you're...
So these are two draft ordinances. This is not a referral from the council. These are drafts for the planning board to consider. The first one, I'll go in order of the, in the packet. The first one is on garden sheds. Currently, right now, garden sheds are regulated in two ways. One is in the zoning ordinance. If a shed or accessory structure is 100 square feet or less, the setbacks are relatively small, 3 feet, 5 feet, something like that. The second, it goes over 100 square feet, so if somebody wants to put in a 10 by 12 shed for their tools, the setbacks go as up to 25 feet, some zones as high as 75 feet, 100 feet, and, you know, people, in my opinion, residents rightfully complain that, you know, I'm putting a 10 by 12 shed and it has to be in the middle of my yard. The code as well, currently right now, the construction code is second and a structure goes over 100 square feet, you require a zoning permit, but you also require construction. Talking with the construction official, I guess it's the state that does the uniform construction code is in all likelihood going to change the code so that only structures over 200 feet require, you know, square feet require a construction permit. So the thought was to basically move the zoning ordinance along with that change, so that that sheds that are 200, up to 200 square feet are allowed to have those smaller setbacks. And again, once it goes over 201 square feet, then that would be subject to the larger 25 feet, 50 feet, depending on what zone you're in. In my opinion, I think it's a reasonable change. In my opinion, I think it's long overdue. There are some provisions in here, some safeguards. Currently, the ordinance also limits the height of garden sheds that can be subject to that smaller setback at 10 feet. In the draft ordinance, I've suggested bumping up to 12. Just looking at Lowe's and Home Depot and the size and the specifications for sheds, some of the ones that are 10 by 15, sometimes they go up to 11 and a half, 12 feet. So there's a little bit more flexibility. But then once it gets higher than that, sorry, you'd be subject to the higher setbacks. At least that's the proposal on here, unless the board feels differently.
So what would be the actual number for the setback on these 200 square feet or less?
I did not bring, I should have brought it depends what zone you're in. But for example, there's a lot of the zones, the setbacks for a 100 square foot shed right now, it's 5 feet.
Okay.
The second you go to 101, it goes up to 25.
So it'll be whatever the lesser is in the zone.
Yeah, so what the ordinance does, yes, the ordinance doesn't actually change, the ordinance that's before you doesn't actually even change the setbacks at all. What it does is it changes the footnote.
Right.
Because the way that the ordinance says is where it says garden shed, and it says a garden shed shall be anything that's 100 square feet or less. Well, the ordinance just changes that to 200 square feet. So the actual setbacks in all of the different zones stay the same. It's just that the size of the shed that can be, subject to these lesser setbacks goes from 100 up to 200 square feet. Obviously, other safeguards like building coverage, impervious coverage, those are unchanged. There is a section already in here that says that if it requires basically a setback when you can't put it right next to somebody's house. If you're going to, it has to be set back from an adjoining house, at least subject to the larger setback. So this is basically to allow people to put it in their kind of the back left, back right corner, and a little more flexibility in the placement of those type sheds.
Do you need a motion? Is that what you're looking at?
You don't really need a motion. This is a work session. I mean, unless somebody raises an objection, it'll get forwarded to council, and it goes through that normal process where it gets kicked back to you as, for the actual referral. I think I've said in the past, looking for positive head nods unless there's any negative head nods.
Yeah, I think it's a good idea.
Okay. The second ordinance is something that the redevelopment agency has been working on for some time. There's a piece of property that is in the Leawood redevelopment area. If you recall, the Leawood area is 200 or so units build out for townhomes and condos with a 50% affordable component. There's been some talk with the developer to eliminate one small portion of their redevelopment area. In fact, it's the only area that they have that actually fronts 27. And there's a long process involved in doing that. But one of the steps that would have to happen is, or let me take one step back. By eliminating this area that fronts 27, it would allow the property owner to develop it for a small commercial site. Similar to, this board approved a small, I forget, what is the name of it? I forget the name of the development, but there's one right up the road in front of the Leawood development where it's a small convenience store with parking in the back. This would be a similar type situation, convenience store in the front, parking in the back. And then the rest of the Leawood would develop as it's currently planned. So what the ordinance does is it basically extends, it keeps the development or keeps the site in the zone, the multifamily residential zone, but it extends the neighborhood business overlay zone that extends down 27 to encompass this site. So it allows the possibility for, if right now the redevelopment agency is in talks with the property owner and Leawood, if those go through, then again, it'll be developed as commercial development, and this overlay zone would allow that commercial development to happen. If those talks don't go through, kind of fall through, it would stay within Leawood's development and it would stay within that multifamily residential zone. So this ordinance basically allows both of those possibilities. And it's really that's basically.
So in other words, the NBR is the overlay.
The NBR is the overlay, and the multifamily residential would stay in place to allow this, to allow both things to happen.
Can you just give the board like an overview, kind of an idea of exactly where this is? Because I'm looking at your exhibit, and it's just so zoomed that I can't quite get context there.
Well, this would be at the, well, if you look at, I'm going to point to this map. Yeah, unfortunately, the streets didn't show up. But basically, this area right here, that's basically First Baptist.
Oh, okay.
That's the end of Lee Woods redevelopment area. I think that's, is that Oak? Yeah, Oak. That's the end. So it's
Okay.
basically the few blocks going north from
Okay.
Oak.
Thanks. Don't want the board to
No,
be
I
approving
think,
something of where it is.
There are a couple of buildings there that are essentially mixed use. They seem to have both inhabited and selling ice cream or something like that.
Well, yeah, well, this
What's
particular,
existing now, that's presumably going to be redeveloped out of existence one way or another, but
there's a house, then there's a site in between that's entirely undeveloped. And then I believe there might be one business, in
you know,
that
the
location.
corner of Oak, there was a decrepit building which was finally eliminated a few years ago.
Sounds good. Thanks, Mark. Just one question before we adjourn. Where are we on the, I get asked this from time to time, where are we on the master plan?
Where we are on the master plan is, we just recently got comments back from the state within the last 2 weeks or so on the farmland plan. They're not significant, but numerous, so I need to go through those. The plan is to present those as well as the ERI and the historic element, all of which have been prepared, kind of all at once rather than do it piecemeal. We could start doing them. That was the original plan, but it took so long. The land use element, I need to do, but I'll be honest with you. I'll just say we're one person short. And I'm basically doing 2 jobs in the short term. So I have, I think, a few more hats. So for the time being, it's not getting done. The goal is to get it done by the end of the year. And the transportation element, if you recall, you went over and basically approved a outline for that, and we need to get that out for RFP.
Okay.
So
As long as we can, you know, I know because we have our usual, I think, August recess coming up. So, I mean, I wouldn't expect anything to get done before that, but, you know, then in the fall. You know, I wanna make-
if we do need to hire a new zoning officer to do the day-to-day, hopefully we get that soon, and hopefully my schedule will lighten up and I can be able to get back to that and get it done.
All right. Thanks.
Mr. Chairman, along the same line, have we heard anything further about Mount Laurel?
No, not really. That's out of our hands. It's still in the courts, and we're waiting. I guess I could say we're waiting for our time before the judge, and that time hasn't come yet.
Thank you.
All right. Motion to
Motion to
adjourn?
adjourn?
Second?
All in favor?
Aye.
Aye.